Thank you so much. Hello everyone. I'm Shishu Ranjan, and today I'll be moderating this session to discuss about the book by Dr. Oishik Sircar that he has written. The book name is Ways of Remembering Law, Cinema, and Collective Memory in New India. So before starting, I'll just give a brief outline of the session. So first, I'll be giving introduction of the author and the book reviewer, uh, Mr. Jisan. After that, we'll go on to the book that Dr. Oisik will be discussing. Uh, uh, I mean, the process of writing, how he went to the ground, how he conducted his research, by going through different uh, different court orders and then cinema that he's using as a methodology in his book. Along with that, book writing is a very challenging process. So how he dealt with all these processes during this process. And then for 15 to 20 minutes, Mr. Jisan will be talking about his own reflection of going through his book, through this book. And along with that, he'll be bringing his reader's perspective on that. And at the end, for 10 to 15 minutes, we'll be taking up questions from our listeners. So I would request everyone, if you have any question to the author, kindly write in the chat box, or you can unmute when the session will be going on. You can unmute yourself and then you can ask your question. So I'll be introducing Dr. Oisik first. Dr. Oisik is a senior lecturer at Melbourne Law School, where he teaches torts and legal theory in JD program and international human rights in the law masters. Prior to joining Melbourne Law School, he was a professor and founding faculty at Jindal Global Law School, OP Jindal Global University, where he taught different courses such as jurisprudence, torts, and criminal law. Along with that, Oisik has held visiting positions at National Law School of India, Bangalore, Women's Studies Center, University of Pune, West Bengal National University of Juridical Sciences, and University of Calcutta. Oisik is a theorist of relationship between modern law and violence, and his research joins with traditions of legal scholarship in the field of post-colonial studies, queer theory, cultural studies, and left and feminist social movements. Uh, Oisik is author of two books. First one is Violent Modernities, that was published in 2021 by Oxford University Press. And the second book that we'll be discussing today is Ways of Remembering Law, Cinema, Collective Memory in New India. And that is published by Cambridge University Press recently in 2024. He's also co editor of two landmark volumes on queer politics and the law from Juban, New Intimacies, Old Desires, Law, Culture, and Fair Politics in Neoliberal Times. That was published in 2017. And Desire and Its Discontent, Queer Politics in Contemporary India, that was published in 2024. Oisik is also the co-director of the award-winning documentary film We Are Foot Soldiers, that was released in 2011. His Osgood Hall Law Journal article Spectacles of Emancipation Rethinking Rights in India's Legal Discourse won the 2014 UK Socio-Legal Association Article Prize. Along with that, he's keeping on some editorial board of Australian Journal of Asian Law. He's also the advisory board of Indian Law Review, and previously he was the editor of Jindal Global Law Review. So today he'll be discussing about his book. Now I would like to introduce Mr. Zeeshan Ahmad. He's a lawyer based in Delhi. Currently, he's working in High Court and different courts of New Delhi. Uh, Along with that, he has done his LLM from SOAS University of London as a Marangom K overseas scholar. Before that, he has done his LLM from Azim Premji University as well, and his BLLB from Aligarh Muslim University. His writings can be seen on The Wire and Leaflet. He has written tremendously on constitutional morality, democracy in Indian context, where India is changing, India's political scenario is completely changing. So yeah, I'll give this session to now Dr. Oisik will be discussing about his book, his methodology, and uh, the things that yeah, we are gathered here to discuss about. So, Dr. Oishik, now I would like to hand over this session to you. Thank you so much.
Thanks a lot, Shishuranjan. And thank you to Speaking for Margin for this opportunity to talk about ways of remembering. It's about 2 years since the book was published, and it's a rare privilege to be able to talk about it and have a group of kindred um, readers, or at least those who haven't read but are interested in reading, join a forum like this. Um, I also want to thank uh, Zishan. It is an onerous task to take on the responsibility of reading a full book and getting a short amount of time to talk about it. But I hope the experience wasn't too daunting, or I should say too boring. I hope it was worth your time. Um, Let me begin by acknowledging that I am speaking to you from the lands of the Wurundjeri people of the Kulin Nations. And their sovereignty over this land has not been ceded. And I pay my respects to their elders, past, present, and emerging. Now, it is a standard convention if you work or teach at a university in so-called Australia to begin anything that you do with what is called is a land acknowledgement. It is become such a regular convention that people do it as a matter of um, symbolic um, acknowledgement of the fact that this land belonged to its indigenous people and was taken away or stolen. And that's where most of all the universities in Australia stand. Now, I say this not just merely as a matter of convention, but also to actually acknowledge the material reality of the fact that even as a migrant from outside of this land who's here, who wasn't necessarily part of the colonial mission that stole the land, I am still the beneficiary of that history of loot and its ongoing violent ramifications. So I don't stand outside of the complicity that the acknowledgement demands of those who live and work on this land. Um, so to now say a little bit about my book, Ways of Remembering. Uh, the book, for those of you who haven't read it, is a book about uh, what is commonly referred to as the 2002 Gujarat pogrom. Um, that's not the only way it's referred to, and I'll come to how else it's referred to. Um, in 2002, large-scale violence led by Hindu mobs, or singularly targeted Muslims um, across major cities, um, and uh, some peri-urban areas in Gujarat, resulting in killings, arson, massive displacement, egregious forms of sexual violence, um, and of course, the loss of uh, health, and massive uh, destruction of property. Uh, and just uh, a few weeks into the start of the violence, which started um, on 27th of February, um, 2002, and the violence carried on for over 3 months. But its most intense period was the initial few weeks. So soon after the violence started, I went to the city of Ahmedabad with a fact-finding team that was put together by the South Asia Human Rights Documentation Center. And as a young human rights lawyer, my task was to collect victim testimonies. Uh, and and a visit that was meant to be for just a week lasted for much longer than that. Nothing came out of my visit. All the plans that SHRDC had about what they will do with these testimonies, didn't lead anywhere. Um, but the visit fundamentally altered my, you know, sense of being, uh, and impacted on the way or the course that my life took from that experience onward. Um, now, uh, about 20 years after that, the books come out, and uh, the book, in a certain sense, is an acknowledgement of how life-altering that experience was. But let me share three key reasons, why I wrote the book. Now, the book is, of course, about Gujarat 2002, but it's not just about Gujarat 2002. It's about something else as well. It's because there's a huge amount of literature on the pogrom that's available, and this is literature that covers not just academic or scholarly work, but also activist writing, um, artistic works, and a lot of very, very good reportage by journalists. Um, um, what motivated me to return to the experience of my own experience of being in Ahmedabad and in Baroda in 2002, um, so many years later, to write a book, was something that I hadn't thought about when I was there in 2002. So as time progressed, my interest in legal scholarship um, uh, was focused on a field that's broadly referred to as law and humanities. It's a field where those who are doing this kind of scholarship called law and humanities are interested in thinking about the discipline of law as a humanities-oriented discipline. And for that, what those of us who do law and humanities scholarship try and look for is we go in search of law in what can be called is the wrong places. So you wouldn't necessarily read the most conventional of legal texts to look for legal wisdom. So you wouldn't go to the standard statute, or you wouldn't go to the standard case law, or you wouldn't go to the standard, commentary by a jurist. But you would go to, so-called unconventional locations to look for legal wisdom, like, novels or poetry or cinema or advertising or pamphlets, or sometimes even dreams. Um, so that's the field I got interested in over time. And in a certain sense, the book is about Gujarat 2002, the event, but the way I approach my analysis of that event is through this scholarly field called law and humanities, and more specifically, law and cinema. So the wrong place that I go to look for legal wisdom is cinema. Um, but the book is also about something else, which is that it is a scholarly inquiry into the relationship between law and violence. In that sense, it continues from the kind of inquiry I undertook in my earlier book, Violent Modernities. And that inquiry, for example, is interested in looking at this relationship between law and violence, not as a relationship between antagonists, which is, law is meant to prevent violence, or law is meant to rectify violence, law is meant to repair the aftermath of violence. Uh, Rather, I'm interested in looking at how law and violence in modern polities are, in fact, they share a very intimate relationship. So, in the name of preventing uh, violence, law, in fact, becomes a violent a discourse, both a discourse and an agent of violence. And so it's that inquiry that is carried through into violent modernities as well, into ways of remembering as well. Now let me talk about three reasons why what motivated me to return to Gujarat 2002. Uh, why I hold on to this field called law and humanities, to do the kind of analysis that I'm doing. So the first reason uh, is autobiographical. So as I said, I was in Ahmedabad right after the pogrom started, and I was living in uh, an area, an upmarket area, on one side of the Sabarmati called the Judges Bungalow Road. Now, this is the more modern part of the city. Uh, it's uh, it's the more affluent part of the city, and it's also the Hindu part of the city. And I was living with the Hindu family there, who I didn't know. Somebody in the team had relatives there, and we were living with them. And so every day, uh, we would take this auto rickshaw from Judges Bungalow Road, cross the Sabarmati to the other side of the city, which is the less affluent side, which is the visibly Muslim side of the city, to go to the Shah Alam Dargah. And the Shah Alam Dargah was at that time turned into a makeshift refugee camp because of the kind of displacements that had taken place. So our interviews were taking place at Shah Alam Dargah. Now, of course, my most memorable, uh, you know, accompanist on those auto rides was this really fat volume of criminal major acts, because we were constantly looking at sections and provisions that might apply to the kind of testimonies that we were collecting. Um, this was also because Indian criminal law is woefully inadequate for addressing collective violence. So the only provision kind of that was applicable, or unlawful assembly or rioting, but those seemed quite inadequate for the kind of experiences we were recording through our interviews. Now, it's much later when I got interested in the field of law and humanities, and I started, reading novels or poetry, or watching cinema for legal wisdom, and when I started work on the book, that it struck me that quite subliminally, The other thing that accompanied me as I took these auto rides from Judges Bungalow Road to Shah Alam Dargah and back every day were big painted faces of Bollywood stars. So if anyone's been to Ahmedabad, it's very ubiquitous. You get into an auto, all of these autos insides have photos or paintings of Bollywood stars. And and it so happened that, about a decade after the pogrom, when I started working this on this book as a PhD project, I was in fact thinking about how law and cinema could speak to each other to reconstruct memories of the Gujarat pogrom. So that, in a certain sense, is the personal or the autobiographical anecdote that served as one motivation for the writing of this book. The second is somewhat disciplinary. Uh, there are different ways of doing law and film scholarship, and one of the obvious ways of doing law and film scholarship is to read or look at cinema to see whether cinema represents law properly, right? So, are they getting the sections right? Is this how cross-examination takes place inside a courtroom? So it's what is called the mimetic mode of reading films as a lawyer, So are films miming law properly? That's not something that I do in ways of remembering. I'm not interested in whether the films that I study in this book are correct representations of the law or not. And I come to why I do that a little later. So um, there's another way in which those who do film and law scholarship approach films, which is to to do so by looking at the relationship between law and cinema as a relationship of regulation, where law has the authority to regulate cinema. And this regulatory authority comes from the fact that law takes on this responsibility to regulate something which has the capacity to hurt, be harmful, or corrupt. Uh, and this regulatory authority of the law is performed through the Indian Cinematograph Act, through something called the power of prior restraint, that the law gives to the government through the way in which the CBFC works. Now, there was a challenge against this prior restraint uh, regulatory authority many years back, and the Supreme Court had delivered a judgment on this called the K. Abbas versus Union of India judgment, a very well-known judgment. Whoever does law and film scholarship in India are interested in questions of censorship, etc. You cannot not cite the K. Abbas judgment. Now, why I mention this? In this book, I'm not doing law and cinema scholarship in that regulatory mode. So I'm not interested in whether what kind of prior restraint is imposed on these films, what kind of regulatory authority that does the state exercise on these films. I mean, there are mentions of those, but that's not the kind of analysis I undertake. But the reason mention the K. Abbas judgment and why that is the second motivation for taking on this kind of an inquiry is because there's something quite unique that the K. Abbas judgment says about cinema, which is that it singles out cinema um, as a form of art which has this exceptional capacity to adversely impact what the judgment calls our immature minds. And thus it says that prior restraint is justified. But that's not, for example, an exceptionalization that books are, That's not the kind of exceptional status that, for example, other forms of art like books or painting or poetry uh, is uh, is at the receiving end of. So you can't have prior restraint of books. You can't have through what the K. Abbas judgment says. So I was quite interested in looking at what exactly is the power of the moving image that makes it so exceptional for the law, that troubles the law, that makes the law want to regulate it in this way. Um, the third reason for working on the book uh, flows from this, which is the reason why law tends to treat cinema as something that requires regulation is because law considers that it has a primary claim over what is called factual. But any other artistic mode in which history is represented or talked about is necessarily fictional. And if it's fictional, then there's a dilution of that factual element. And the law tends to take on this responsibility of correcting it if something goes wrong. And so the law works on this very clear understanding of fact and fiction when it comes to what is law and what is cinema. So law is a discourse of facts. There's a commitment to the idea of truth, whereas cinema is a discourse of the fictional, which does not have a commitment to the idea of the truth. And as I demonstrate in the book through my reading of a set of films on a set of feature films on Gujarat 2002, and my reading of the best bakery judgments, uh, what I try and demonstrate is that this fact fiction divide, in fact, gives away. And the law in the way in which judicial reasoning is carried out through the best bakery judgments rely as much on fiction or fictionalization that the films you know um, um, build their narratives around what it considers to be factual. So uh, the films and the judgments tend to use similar kinds of rationalization when it comes to their methods of reconstructing what happened in 2002. Now, given these three motivations, what exactly is the book doing? The book has a very narrow inquiry. It looks at the immediate post-pogrom decade. And there's a reason why it looks at the immediate post-pogrom decade is because that period has been quite fundamental to the kind of turn that the Indian polity has taken, 2014 onwards. So the precursor to the 2014 moment, in my assessment, uh, you know, was the script for that was written in those 10 years. Um, and I look at that concentrated period as an argument for demonstrating what I have called previously the new India, an idea that I developed in my earlier book, Violent Modernities, and I hold on to that idea in this book as well, um, whose genealogy can be traced, you know, further back, but it fructifies really in this, post um, Gujarat pogrom decade. So what do I do when I'm looking at this post-pogrom decade? I look at one of the most controversial uh, criminal trials related to the pogrom, which was the Best Bakery case. Um, and I look at it primarily because it was one of the first trials to start, but also because unlike many other trials, it's the trial that had um, um, two key elements that distinguished it from other trials. One was that um, it worked up through the entire hierarchy of the Indian judiciary, starting from the fast track court in Baroda to the Supreme Court. And the second was that for the first time in the history of criminal trials in India, uh, the Best Bakery case resulted in the Supreme Court moving a trial outside of the jurisdiction of the occurrence of the event of the crime. So, uh, because the Supreme Court recognized that the conditions under which the trial was taking place in Gujarat were so deeply compromised, resulting in the star witness, Zahira Sheikh, turning hostile repeatedly, that it asked that the trial be moved out of the state of Gujarat, and then a new trial was carried out in Bombay. Uh, and there was actually a third reason why the Best Bakery trial was so significant, which was that unlike the other trials related to the pogrom, the 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 first two judgments in the Best Bakery case resulted in full acquittal of all the accused. Right, so there wasn't a single accused who was convicted, both at the fast track court level as well as on appeal in the Gujarat High Court. So that's the reason why I look at this particular trial. Um, Now, in this 10-year period, or 10 to 11-year period between 2002 and 2014, parallel to the running of the trial, there were three uh, films coming out of Bombay um, that were directly about Gujarat 2002, but they came out at different times. Uh, the first one being Govind Nihalani's Dev, the second one was Rahul Dholakia's Parzania, and the third is Kaipoche. And they come out at different stages, and I started to kind of see whether what was happening in the Best Bakery trial, given wherever it was, which court it was in, was somehow being reflected, not exactly about what was happening in the court, but the nature of judicial reasoning was reflected in the way in which the memory of the pogrom was being reconstructed in these films, right? Uh, so I look at law and cinema in this 10-year period post 2002 as a shared repository of collective memory, um, rather than a, a repository of a collective memory that are telling very different stories, like one telling a fictional story and the other telling a factual story. Uh, what I argue in the book is that law and cinema form a narrative compact, that they are invested collectively in producing a certain way of remembering the pogrom. And that's what I demonstrate in the book. And for this, I develop a method, and I'm not going to talk about the method, but happy to elaborate on it later if anyone's interested. It's a method called, and I don't actually call it a method in the book. I call it an approach. The reason I call it an approach is because I find the word method to be um, too too formulaic, meaning, it's like it's something that's portable. I have used it, so someone else can use it as well. I don't know if anyone else can use it. I could use it. It was helpful for my purposes, but it might not have any life outside of this book. So it's an approach, a way of seeing, an orientation, a lens that I found useful because I was trying to read law and cinema as a shared narrative. It's an approach that I've called the jurisprudential aesthetic approach, the jurisprudential aesthetic lens. And as I've said before, the aim was to look for the aesthetic dimensions in judgments and look for the jurisprudential dimensions in films. Um, that, in a certain sense, is the disciplinary work that I was doing, which is to say that law's constant attempt to separate itself from the aesthetic, that the aesthetic is something else. We are driven by reason and objectivity and neutrality and a certain commitment to truth and determinacy. Um, and aesthetics is a field of those who are interested in the frivolous or the ephemeral or the affective. Uh, it's that unhelpful divide that the book, in a certain sense, tries to unsettle, to demonstrate that almost all legal reasoning is imbued in aesthetics. It's inseparable from the way in which judges conduct themselves through language or the use of certain kinds of expressions and or what in the book I call tropes. Um, and similarly, cinema, which is an aesthetic, you know, form of sorts, um, has elements that train us to think about the law in a particular way. And so law and cinema then start mirroring each other uh, rather than being discourses that are opposed to each other. Now, let me end by just pointing at a couple of things that I draw out from my reading of of the films and the judgments. The first one is the the way in which the films and the judgments construct time, because that has much to do with the way in which collective memory is narrated by the films and the judgments. And this kind of takes me back to what I was saying earlier, which is the way in which the violence of 2002 is referred to in everyday public discourse. So the standard expression, even in most progressive media, is post Godhra riots. Now, and the films and the judgments do the same. So, except for Parzania, that uses the word genocide to talk about what happened in 2002, and which is a legal category. Uh, and so Parzania has a has a better lesson to offer in the way in which a legal category applies to our understanding of what happened in 2002 than any of the best bakery judgments do. Um, so the construction of time operates in this way, that something happened in Godhra, and everything that followed from that is because what happened in Godhra. So Godhra becomes what has been called by the literary scholar David Kazanjian as the history vanishing moment. It's the flashpoint that has such a spectacular effect on the way in which we try and understand an event. It basically stops us from seeing what happened prior to it. It becomes the point at which history begins. Now, this isn't something particularly new in terms of the method of reconstructing memory that was taking place with regard to 2002. So if progressive media, including news outlets like Wire or Scroll, or even if anybody's read Joe Sacco's new book, The Once and Future Riot on the Muzaffarnagar riots. Even Joe Sacco uses the expression post-Godhra riots. Um, now, um, now, I'll come to what the problem with the use of the expression post-Godhra riots is in a bit, but it it follows a standard script of the way in which majoritarian violence justifies itself. Um, so take September 11th, right? So the date on which the World Trade Center attacks take place becomes the flashpoint moment. So we are then trained from that moment onward through the way in which media reporting takes place, the way in which a new kind of discourse begins, that all history must be traced back to that moment and not before. Now, the post-Godhra rights expression follows suit from that. It's that same logic at work, right? So one shouldn't actually be concerned or be interested in the longitudinal history of uh, you know, anti-Muslim sentiments in Gujarat. One shouldn't necessarily be interested in the fact that the organization of arms or the access to, census lists were made available much before Godhra took place. And Tista Setalvad has an important, useful expression to describe this. She calls it the who threw the first stone thesis, which is that the way in which you justify majoritarian violence is by pointing fingers to Muslims by saying they threw the first stone. So if now 100 stones are thrown in response, that stands justified. And we see that that logic of justifying majoritarian violence continues. So October 7th, again, a date becomes the way in which you explain everything that follows from then on, right? So everything happens after that because October 7th happened, right? So if October 7th hadn't happened, you know, the genocide wouldn't have happened. Um, so, so in a sense, um, the expression post Gujrat riot, in the way in which both the films and the judgments construct the memory, tells us that our temporal understanding of the event is being regulated. We are being told that all your analysis should begin from Godhra and not before. So that's one of the things that I wanted to say about what emerges from my readings of the films and the judgments. The second thing that I should say emerges from my readings is a, there's an attempt both by the films and by the judgments to draw a clean distinction between memory and forgetting. And and one of the things that my book argues against is that um, the way in which Gujarat 2002 operates, you know, in contemporary discourse in India is far from being an attempt by the powers that be to make us forget. It's in fact to make us remember it in different ways, right? So it's not about a contestation between memory and forgetting, but it's about a production of a surfeit of memories and a way of training people to remember in different ways. And that's why the book's called Ways of Remembering in a certain sense. So, think about the fact that Gujarat 2002 never goes out of news, right? So you will still have a Sabarmati report. You'll still have that film being declared, tax-free. You'll still have, ministers of the BJP going and watching the film. And that in itself becomes a media event. Watching the film is an event. Um, so I argue that it's unhelpful to think about the relationship between memory and forgetting as oppositional. Rather, here what we have is a, a whole set of ways of remembering, and one such way is the way in which the present dispensation wants us to um, hold on to Gujarat 2002 as a model for whatever has to follow from then on. And finally, let me end with this, which is um, you would see if anybody's read the book, but if not, at least I've mentioned the three films. You would see that the three films that I've mentioned are in fact very different from the more recent crop of what are being called our propaganda films, which are brazenly Islamophobic, which are, there is there is no there is no attempt to um, skirt around the matter, as it were. Right? So there are no. But these three films, Dev, made by Govind Nilani, who's somebody who's well known for making anti-establishment films, well known for making a film like Tamas. Um, you have a film like Parzania, made by Raul Tolakia, and to a slightly lesser extent, uh, Kaipoche. But the important thing to bear in mind about these three films related to the Gujarat 2002 pogrom is that they are all, in some ways or another, critical of the violence, right? So they offer different degrees of secular critique of what happened, right? None of these films celebrate the violence in any way. And yet I found these films, these three films, to be far more insidious with regard in relation to, in comparison to the current crop of propaganda films, not all of which that I've watched, I must admit. And the reason for that, as I demonstrate in the book, is that despite the kind of secular critiques that these films advance, they leave unquestioned um, the idea of India that they hold on to, which is an idea that the films understand to be almost foundationally Hindu, right? So you can have secular critiques of an event of violence directed at Muslims, but sometimes that secular critique can, in fact, strengthen the idea of India as a Hindu nation. And um, just on the aside, I should say that this is an argument that I advance in the book uh, uh, to critique what I have called our secular laws, meaning that, again, much like I say that the opposition between law and aesthetics is a false opposition, like the opposition between fact and fiction is a false opposition, or the opposition between memory and forgetting is a false opposition. Similarly, the opposition between what is secular and what is religious, in the way in which the films and the judgments talk about this opposition, is in fact a false one, because we see that particularly in the case of the Gujarat pogrom, uh, secular laws, or what are called putatively secular laws, played a really important role in enabling the violence to be carried out. And one such illustration is the existence of the Disturbed Areas Act in Gujarat that has resulted in the creation of Muslim ghettos. And so when the mobs were running rampage, they knew where to go, right? There was the the municipal uh, organization of the city made it amply clear to the mobs where the Muslims were and where they need to be targeted. And so here you have an ostensibly secular law at work, enabling something of the scale of the Gujarat pogrom. And I didn't say this, and maybe if there's a question about this in the Q&A, I can come back to it, which is to say that uh, there's a reason why I refer to Gujarat 2002 as a pogrom. There are other words that have been used, like genocide, like riot, like crime against humanity. But there's a particular reason why I call it a pogrom, and perhaps I can talk about it if there's interest in the reason why I think pogrom is a more appropriate description than these other words. But I'll stop there.
Thank you so much, Oishik, for your detailed analysis. I mean, detailed discussion of your book. So now, before moving to Jisan, if anyone would have any question, you can write in the chat box, or you can unmute during question answer session, and you can ask the question yourself. So now over to Mr. Jisan for his reflection, critique, or review of the book. Over to you, Jisan.
Thank you, Sishu. Thank you, Oishik. So Oishik has already covered most of the components of the book with the central idea, the structure of the book. But nevertheless, I'll share my own reflection about the book. The book is much more than what Oishik has said in my reading. Okay. So I'll start with the structure. It's like the book is divided into 5 chapters. Okay. Law and aesthetic as atrocity, about which the Oishik has already talked. And there, Oishik did not dwell upon his approach, which is basically called as J approach, which I found to be very interesting and very relevant for the contemporary time. This it's like its application to many of the judgment which has been rendered by the Supreme Court come as handy in deconstructing the real objective which those messages are trying to the real objective is those judgments are trying to achieve. So this J approach, so it's the abbreviation of jurisprudential aesthetic approach, in short J approach. It does not dwell so much upon the doctrinal analysis of the judgment. Rather, it tries to identify the tropes, and on the basis of that it creates a narrative, and what role does that narrative plays in the manufacturing as well as mobilization of collective memory. This Oshik has shown very aptly in his analysis or in his deconstruction followed by reconstruction of the best victory judgment. Like, just to give you a flavor of that thing, the trial was done by fast track court over there, but this trope of speed neutralized the entire idea of the truth, because the foremost objective of trial is to find out the truth. But with tropes like speed, majestic of the law, crowd, fear, rule of law. The most important aspect, that is the truth, is being made a victim over there. So while reading this judgment through J approach, I was even wondering whether this kind of approach could be applied in the Babri judgment, because in this best bakery judgment, as Oshik has already flagged, that at all the fora, right from the Vadodara Sessions Court to the High Court to the Supreme Court, all the three judicial institutions says that violence was committed, atrocities was committed. However, the the only recourse, or the only way through which justice could be served is through the secular institution or the secular rule of law. Nowhere these the judicial hierarchy talks about the structures, as the witness, the star witness in this case, turned hostile every time. The judge did not dwell upon this aspect. Why was she means backing off, or she was resigning from what she has told to the police? So there is no mechanism to take care of these things. Similarly, in Babri judgment also, the court says that yes, the mosque was demolished. It was a very egregious act. Nevertheless, or despite that, the disputed site was given to the party who was involved in these kind of destruction. So I mean, during the question answer session, I would request Oshik to comment on this thing, whether one can transport, means though Oshik has said like whether it's a one time kind of thing, it was just devised for this very particular purpose, but nevertheless, we would request you to comment on this thing. Let now coming to the next component, the name of the book is very important. Means like, as Oshik has said, remembering something is one thing, but remembering something in a very particular way is quite another thing. So while reading the book, we come across this this historiography, which is not the conventional historiography called as Nemo history. In Nemo history, memory is structured in such a way that it is related to the ways in which history is remembered. Why this is done? The answer which get in the book, and by going through the work of John Ashman, who was a cultural historian, it says that that particular memory is used for the purpose of mobilization, and it and through that a cultural memory, or a collective memory is created. That collective memory has nothing to do with the fact of the incident which happened in the past. Everything which is concerned with that collective memory is how things are remembered, and it is a very pedagogical exercise. It has nothing to do with the truth. So that is why the name of the book and the methodology through which the judgment has been read and the film has been watched is very important. Now I'll come to the third component, that as Oshik has said, like the larger argument of this book is built, or it takes inspiration from his previous book, Violent Modernities, in that it said that the atrocities that was meted out to the victim of the program didn't happen outside a secular setup. It happened within the secular setup, which includes the institution as well as the law. So the accused as well as the institutions are complicit in this thing. With this argument, there are two other things which Oshik says in this book. This helps in state making as well as state preservation rationalities. So what are these rationalities? These rationalities are secularism, legalism, and developmentalism, which Oshik further shows is the building block of the idea called as New India. The one of the thing which I didn't get clarity in the book, though it's mentioned in Violent Modernities, like what is this new India all about? Because in everyday discourse, we hear this phrase New India. Generally, in official discourse, it is said that since the time Mr. Modi has become the Prime Minister, a new phase has been inaugurated where a nation who was very suppressed has found a voice. Means, means in the work of political scientist Christophe Jaffrellet, he has a book by the name Modi's India. So I'm assuming something that New India, Modi India, it is, if not identical, there is some sort of similarity. He says that it is the beginning of an ethnocracy. Means like India is no more a democracy under this regime, it's an ethnocracy. But in Professor Oshik's book, what I see that, I mean, and Professor Jaffrey's book is also published, I think, a couple of years ago. But Oshik is saying that this development started in early 2000s. The manifestation of which we saw during the 2002 program, and which further got consolidated over a period of 1 decade. So I'm interested in knowing that if New India got inaugurated, what was the idea of India which preceded it? Because we do not get a clarity, means like what, which India gave way to New India. Suppose if like there were certain components of New India which already existed in the old India, so we do not find anything related to that, in the sense that what were the essential component of that old India? Was it that weak that when this kind of onslaught came, it was so weak that it, without resisting, it gave way to New India? The second thing related to this very question is about constitutionalism, because generally speaking, in a conventional understanding, with what constitutionalism conjures up is a limited government. So Oshik's entire academic exercise in this book is like the system itself is ranged up against the victim. Okay, and they are fighting in a system where where which is guided by majoritarian logic. So there is very less chances that they'll get justice, and obviously do not get it. But what is this constitutionalism which does not protect the victims? So was this constitutionalism, this the underpinning of this constitutionalism was majoritarian oriented since the inception of the republic, or how did it got transformed over the period of time? So this is one of the question on which I would like to have Oshik's views, because nothing much has been said about the constitutional, because I am assuming that if there was a strong constitutional or the culture of constitutionalism in India, it would have acted as a bulwark against these kind of forces, be it in 2000 or be it, I mean, it's like after 2014, whenever they were when we came to power. The third thing that I'm interested in knowing from Professor, I mean, it's not means I'm asking, I'm basically discussing this thing, because Professor Oshik has mentioned, means has referred to the work of Robert Hoover in this thing, that the famous quote, legal interpretation takes place in a field of pain and death. But in that same essay, at one point, Robert Hoover mentions that there is a social conditioning, because if a legal interpretation means if a judge gives a legal interpretation, all of a sudden it does not get translated into a violent deed. It has to follow certain mechanism, because there are other social actors who will get that interpretation converted into deed. In Gujarat program, or the trials which ensued after that, or through the movie, who are these social actors and what are the social conditioning that enabled it? Was this social conditioning present since 1950s, or there is something, means like as you have mentioned, this history vanishing point kind of development in the history of the republic over the past 75 years, which has facilitated these kind of things? the I means reading the book collectively, I get an idea that there is a majoritarian sensibilities which was at the back burner, but with the state power, means it has become the new common sense. So, means coming from this vantage point, I think Rand Herschel in his book Constitution Matters mentions about this idea of meta narrative, which is way above than constitutionalism. Even constitutionalism has to abide to that meta narrative when they both clash. And means like, if basically he talks about Israel, means the Jewish kind of democracy, means like how Jewish democracy survived despite being Jewish and democracy. So he says like all those components which are integral to the part of the Jewishness of the Israel, when it is being adjudicated at a legal fora, and it hampers its core identity, that thing will not pass the muster. Only those things which help in maintaining the liberal facade, because in contemporary time, liberalism is in vogue, democracy is in vogue, no one wants to be called out to be an authoritarian. So can we say that in case of India, Hindutva is that meta narrative? With this I'll stop. Thank you.
Thank you so much, Jishan. Now over to Oishik, if you would like to answer Jishan, and then I would request participants, if you would like to ask any question, please raise your hand and unmute yourself, and you can ask question. So it would be better if you raise your hand and then I'll call the name, or you can write on your chat box. So Oishik, yeah, over to you.
Thank you, Zeeshan, for such a close and considered reading of the book. And I really appreciate the the engagement, but also the questions. And I will try my best to be adequate to the task of responding them. Why I say that is because I haven't read my book in a long time myself. I did read it after it was published, but not necessarily very recently. Um, so uh, you might know better than me what's in it at this current moment. So I'll take the easiest question first, which was the first question that you asked, which is, can the jurisprudential aesthetic approach be applied to the Babri judgment? Uh, my my instinctive sense is yes, perhaps it can be, if it is thought of as an orientation rather than as a method. And I say this, with some thought, because I didn't think about the J lens as something that can be instrumentalized to find some answers, right? So if the aim is to uh, practice a way of reading conventional legal sources like judgments by paying attention to their aesthetic dimensions, yes, the J lens is a helpful one, I would think. But whether it will make us see what I was able to see when I read the base bakery judgments or not, I don't know. And the reason I'm saying is that it's not a method, so it doesn't have that instrumental quality to it, of being able to forecast that this is what you will find. Uh, you know, um, So, so I would say yes, it's portable as far as the orientation that it's trying to build is concerned, but I don't think it's portable in terms of being able to find certain things um, that is more obvious in the use of something that is called a method. Um, uh, and there's a reason again. Let me say there's a second reason why I'm saying this, because what is the JA lens? The JA lens is effectively a way of reading texts. It is a training in how to read. And one of the things that I had to be mindful of, even if I call this book a book that is located in a tradition of legal scholarship whose antecedents are critical in nature, one of the tendencies in the critical tradition of doing legal scholarship is that the scholar quite easily takes on the role of the uh, someone who can exercise interpretive supremacy over the text. So the reader becomes more powerful than the text. And in a certain sense, that's quite a Brahminical move to be able to say that I have exercised complete control over what I'm reading. I am now the expert. And with this method, I will tell you the truth about what I'm reading. Nobody else can because I have the method and you don't. I developed it and you didn't. And so I had to be mindful of the way in which I was developing a mode of reading. And I did not want that mode of reading to take the form of something that gives the user of that, say, for example, me, the capacity to say that I have developed interpretive supremacy over what I'm reading, right? So somebody else might read the same set of judgments and find something else using this orientation. So, and I don't say this lightly in terms of uh, its uh, inability to be portable. I say this as a certain kind of ethics that I bring to the uh, to the approach or method. So yes, I mean I'd love to see someone use it. It will be quite self-aggrandizing for me as a scholar that my method's being applied elsewhere. But I will be cautious of the fact that I don't want this method to become something that enables another reader to exercise interpretive supremacy over texts. Um, what is the new India? Now, uh, here's a very uh, direct explanation that so the phrase is not my invention. Uh, the, the BJP has been using it for a while. So have those who are critical of the BJP and the Hindutva project. So it's quite a portable phrase in that sense. It moves around more easily than the JA lens as an expression. But this is how I understand it. I don't understand the new India as something. So I use the word new rhetorically. It is even ironically in the sense, really, you're calling this new? In a certain sense, there's a certain amount of irony in my use of that phrase. But historically or temporally, if I have to locate a certain time, a period that I would think uh, congeals into something that can be called the New India, generally in more progressive liberal scholarship, one looks at the 1991 moment. And I talk about this both in Violent Modernities and in Ways of Remembering. And the moment is the liberalization of the Indian economy, et cetera, et cetera. While the 1991 moment is important, I think of it as not just that year, but something that comes right before 1991 and something that comes right after 1991. And that concentrated period, in a certain sense, writes the script of what is to follow. So what comes immediately before 1991 are two things. One is the unprecedented military presence in Kashmir, right? So India's military presence in Kashmir takes a form that it hadn't taken before in the late 80s, followed by the implementation of the Mandal Commission report's recommendations, right? Um, uh, and then comes the 1991 moment, followed by the destruction of the Babri Masjid, right? Now, so I generally think about these four events uh, producing a certain kind of combined effect on both the polity as um, which is the state, but also the people in the way in which a certain sense of cultural redefinition takes place. And I talk about this in the beginning of ways of remembering. Uh, and this has major ramifications. One of the key ramifications of this, and I should say this for those who haven't read the book, but Zeeshan might know it, and he had to possibly experience the torturously long section of the book, which is its endnotes. Um, my endnotes are very, very long. They are as long as the book itself, and I don't, and that there's a reason for it. I couldn't tell a particular story in the writing of the book, and that story was the story of Hindu caste consolidation and its impact and role in what happens in Gujarat 2002 and what follows from then on. So the general liberal critique of Gujarat 2002 or of Hindutva or the BJP government is the kind of the communal angle to its politics. But this communal angle is founded on Hindu caste consolidation. And that foundation begins with the implementation of the Mandal Commission reports recommendations in the early 90s. And you see that play out really well, both in the Gujarat story in general, because one of the major scale riots that take place in Gujarat in 1969 is in fact a riot against the implementation of reservations. So public space in Gujarat, in a certain sense, knows what violence is, what majoritarian violence is, organized around the question of of uh, caste-related reservations. Now come to the films. And in fact, the Best Bakery judgments talk about this. They talk about the fact that one of the things that's eating up the fabric of India is reservations. And it's an obiter. There's no reason for the judge to talk about this, but the judge does. And now you come to Kai Po Che, the last of the three films that I look at, and it's a classic example of Hindu caste consolidation, right? So the three protagonists in the film are from the three Savarna castes. They're the best of friends. And what the film, in a certain sense, tells us is that as long as Hindu caste, Savarna caste consolidation remains undisturbed, even under great stress and crises, like where one friend ends up killing the other, the caste consolidation still doesn't break. The the future of India is celebratory, right? So you would still have the Muslim prodigy who turns into this major cricketer playing for India, not asking questions about what happened to his father in the pogrom, um, and everybody's celebrating in the cricket stadium, right? So that, in a certain sense, is the recalibration or the manipulation of memory that kind of cast the role that caste consolidation plays. So again, to say, so for me, the question of the foundational role that and so that's another reason why the story of caste and what its relation is to Hindutva in general, but to Gujarat 2002 in particular, is written into the end notes, right? So, in a certain sense, I'm maintaining the very structure of the way in which Hindutva operates, is that caste consolidation is at its base. And so the footnotes, in a certain sense, demonstrate what that base is made up of. And which is why the footnotes are so long, right? So it's not just because I'm being loyally, which I am. Also, writing a book about Gujarat 2002, I have to make sure that I cover all my grounds in the way I'm citing. But these are also just not citations or references. The end notes are telling a parallel and often overlooked story about the New India, which is that Hindu-Muslim communal conflict is enabled and built over Savarna caste consolidation. So, very quickly, what is constitutionalism for me? I'm not a constitutional lawyer, so um, it's very difficult to say what kind of a lawyer I am. When I published Violent Modernities, right before publication, this is a story I've said many times. So, but it's a really funny story. My uh, commissioning editor disappeared. He just stopped responding to calls, etc. And then I get a call from OUP, and the editor at OUP begins the call by telling me how OUP is closing down its law list. So it's going to stop publishing books on law. And the situation is so dire that they are also decommissioning contracted projects. And I thought, okay, now he's softening the blow, because the next thing this person will tell me is, sorry, this is the reason we are not going ahead with your book, even if it's contracted and you've submitted the revised manuscript. But what does he tell me? He says, but we will publish your book because it is not really law. And so the general anxiety that I had lived with up until that point, where my own colleagues in the discipline didn't take me very seriously because they didn't think what I was doing was law, or the film scholars or the sociologists didn't take me seriously because I wasn't doing sociology or film studies proper in that sense. So somehow that not doing law proper, I stood vindicated. So I'm not a constitutional lawyer. So uh, and I haven't read Herschel, though he was one of the professors when I was studying in Toronto for my LLM. Um, I don't necessarily think about the Constitution as one thing. It's many things. It of course has immense, um, you know, insurrectionary potential against uh, the rise of majoritarianism, and more recent works, Kalpana Kannabiran or Nivedita Menon, as those who write about the law from sociological or perspectives of other disciplines, or, you have works like those by Rohit Day, the more recent book, are telling more hopeful stories about the Constitution by saying that we shouldn't just look at the text, we should look at it, in a more realist way, or what's happening, outside the text, so on and so forth. Like any text, like I would read a novel or a book, I would, for example, read the Constitution, and I would think of it as something that opens both of these possibilities at the same time. The possibility of violence and the possibility of repair exist exist simultaneously when it comes to the Constitution. And so you'll have at the Shaheen Bagh protests, protesters holding up placards saying save the Constitution under onslaught, you know, from the government in power. Um, but the same constitution that needs to be saved also has Article 22(3) that makes it constitutional for the state to have preventive detention laws, under which most of those protesters are now in jail. So it, I have this, favorite word that I've used when I've written about the Constitution earlier in Violent Modernity is a piece called, a chapter called Spectacles of Emancipation. It's a word called pharmacon, which means something that is medicine and poison at the same time. And I think of the Constitution, be it the Indian Constitution or any other constitution, or any other text for that matter, to be pharmacon-like. Anything that is of consequence is medicine and poison at the same time. And that, in a certain sense, is the critical gesture, or the critical ethic that I try and keep alive when I'm reading texts. Um, there is no necessary romance that I attach to the Constitution. Neither am I hopeless about the document. Is Hindutva a meta-narrative? Um, I don't know, because if I'm locating the emergence of what I'm calling the new India at a time when Hindutva was there but not in the way it is, then I think it is a meta narrative. Something is a meta narrative. The Hindu foundations of the idea of India that is Bharat, as Article 1 of the Constitution says, is a meta narrative. Whether it's a Hindutva meta narrative or not, I don't know, in that named form. Because I think, irrespective of which political party you're thinking with, a certain commitment to India that is Bharat's been present across the board, right? Um, and so uh, one party is owning it with with greater emphasis than another. So yeah, so I don't know whether Hindutva in named form is a meta narrative, but there's something akin to that that's been around for, you know, much longer. Though, while I say this, I don't just want to say that everything is the same, because I do think Hindutva itself has undergone changes over time. So the current version of Hindutva that we're seeing, I think, is not a version that necessarily is the same as the 1920s version, or is the same as the early 1990s version, right? So the current version, in my understanding, is a unique, coming together of liberalism, fascism, Zionism, and Brahminism. So there are elements of all of these ways of thinking about how to organize a polity that is playing a role in the current way in which Hindutva is operating, and not just in a top-down fashion where you have, the head of the state or the ideological organization telling you what to do. It's so much more dispersed that people are inventing their own ways of thinking about what this thing is. Um, so I don't know whether that's an adequate answer to the questions you had, but I should say I'm not a sociologist. I've not gone out into the streets to interview people, and there's enough numbers of people, including somebody like Christoph Jefferlot, who's done that work. So um, I can only offer reasoned guesses, nothing more than that. Yeah.
Yeah.
So
Sorry to cut you short, Oishik, right now.
no,
Since
that's
we
all
are
that I had to say.
Yeah, we are running short of time right now. So we have a question on our chat box. So would you like to read me for you, or would you like to go by yourself? There is a question in the chat box by Sohini Sengupta. So yeah. Also, I would request others also if you have questions, it would be better if you write on the chat box so that at once he can take questions, because maybe by 10 to 15 minutes we'll try to wrap it up. So yeah, over to you, Abhishek. Can you go through the question?
Yeah, I'm looking
So
at Shohini's question. Thank you, Shohini. I don't have a direct response with regard to how Sarah Ahmed talks about affect, but I can only say something that comes to mind, and this is connected to my use of the word pogrom and not say genocide. Uh, and that has something to do with the question of affect, because one of the reasons why, even if genocide was appropriate or morally more appropriate as a category that applied to Gujarat 2002, one of the reasons I don't use it is because I think the definitional demands but too much. So there's a certain kind of legalism that is so intrinsic to the use of that word that using it requires you to say that what you're describing meets the requirements of the description. And um, um, uh, there's a really good book called The Problem of Genocide, where this is discussed at length in what the burden of legalism does to that word. And because I didn't want to use a term that was legalistically predetermined, I used the word pogrom, which was descriptively closer to what had happened in Gujarat. But when I went to Gujarat, both in 2002, but also later again in 2012, I realized that when speaking to people, I would never actually hear the word pogrom or genocide or crime against humanity. So these were just being used by activists or academics. The words on the street that were being used were words in the vernacular, like, say, for example, hullar or kayamat or andhi or tufan. And there's something about the use of those words which tell you that memorial reconstruction is seldom factual, right? It's always affective. So when you're using the word tufan, you're not referring to a tufan. You're referring to, uh, violence that killed people. But what you're using, the expression is an affective expression of of what had happened, even when somebody actually didn't live through that time. Um, and more recent conversations in public international law, where arguments have been made that even genocide falls short of describing what's happening in Gaza, that there's a need to recover words like Nagba or catastrophe as doing more than a word like genocide uh, can be helpful. So again, not a direct response to your question, but Akanksha, thank you for that question. And I don't know how to how to answer it. I'm not a big fan of the word method, although anybody writing a PhD in any discipline will have to navigate and live with that word. I somehow managed to write a PhD without using the word method to describe what I was doing. Um, it's effectively a method, commonsensically, the jurisprudential aesthetic lens is a method, but I'm mindful of the fact that I wasn't using it in an instrumentalist way. As I had said before, whether it does the kind of interpretive work that I'm suggesting that it does, will be for others to say, or I will possibly have an answer when I write something else by using the same approach. The thing is, since the book came out and I have had a child, I have not researched or written anything new. So I don't know what work the jurisprudential aesthetic lens does beyond the material that I have read for the book. So, so yes, so I don't know. Yeah, so I can't overstate its use beyond how I have used it in ways of remembering. Mm, Tapan, thank you for that question. Uh, I think you will have to read the book. I don't think I can explain how it helps us understand the relationship between law cinema and collective memory here. I mean, I would have loved to take a shot at it, but we are, at a point in the discussion where it would require us an amount of elaboration that I can't go into. But only to say, as I was saying before, the lens is an orientation that is training the reader of legal material to look for the aesthetic dimensions of that material. So to not reduce material that is conventionally legal to just what is legal about it. Um, so, you know, what are the turns of phrases that judges are using? How are they describing things? Are they using one word repeatedly? If so, what purpose is that serving, for instance? Um, and similarly, if you're reading aesthetic material, don't reduce that material to its aesthetics alone. See if that aesthetics contains some kinds of legal wisdom. Um, Oppo, I don't know whether it's your name or it's the name of the phone that you're using. Uh, uh, um, you have used the expression riot, which possibly might be inappropriate for what happened in 2002. Yes, I think part of what you're saying is correct. And so that again demonstrates that uh, uh, this homogenized opposition that standard narratives of communalism produce, which is Hindus versus Muslims, is seldom helpful because there is no homogeneous Muslim community either, and there are strong class caste um, dimensions that produce effects in light of situations like a pogrom. And one could say that about what happened on the other side as well. And this is well documented that uh, the Hindutva outfits were able to recruit, both Dalits and Adivasis to be part of the crowds that went out and carried out the violence. And part of that has been a standard, you know, uh, operation or practice of the RSS, which is to try and Hinduize Adivasis and to bring Dalits into the Hindu fold, or a promise to bring them into the Hindu fold by the creation of the idea of the common enemy in the Muslim. Um, uh, Akanksha, thank you. My very expensive and detailed bibliography and footnotes have a whole range of references. Um, I should say this. I don't, can Anna's archive be accessed in India now that LibGen has been? No, no.
Yeah, I think I have accessed it,
Anyway, it
so
doesn't. I
can
mean,
be accessed
so
using VPN. Yeah.
when Violent Modernities came out and when Ways of Remembering came out, I put on the PDFs of both my books on LibGen. When LibGen shut down, I think they moved all that was on LibGen to Anna's archive. So if you can access it, the book is there, the whole PDF. If you can't, I'm happy to send it to the organizers and they can share it with everyone whose emails are available. So you can then have the PDF of the book.
Now I think Vidyasagar has some questions. So Vidyasagar, unmute yourself and then yeah, go ahead.
Thank you, Oishik, and thank you, Zeeshan, for such a wonderful and very thought-provoking discussion. I mean, I'm not in law in any way, I'm in anthropology. So, uh, I was wondering while listening to you, Oishik, that whenever we talk about collective memory, and definitely there are different institutions and stakeholders are involved in making and constructing any collective memory. And as a researcher, when we approach, especially to deal with sort of work which is related to collective memory, it depends whether you're in law or cinema or any film studies, the evidence you collect, right? The certain evidence, certain incidents, certain events, and the way of selection also determine the another forms of violence. The one violence which happened, and another form of violence which is probably depends on the selection of the evidence you gathered, right? The second form of violence by just depicting one form of violence as legitimate and legible, but other forms are not legible because you didn't pay much attention on those selection. So I was wondering, how do you deal this tension when you started writing, especially such a sensitive and politically such a provocative topic, where lot of constellations are involved, lot of social identities, cultural identities are interplaying to shaping those memories. This is not just about Muslims or non-Muslim. So how did you deal this? How did you navigate this tension while developing and also writing the text? This is I wanted to hear from you. I think
Oh yeah, you need to unmute
Um,
yourself.
I think my response would be that I, as a legal scholar who was not doing, when lawyers do the kind of work that anthropologists do, they work in a field broadly called, you know, socio-legal studies or law and society. Um, but this book is not a law and society or socio-legal a book that falls within that field. So I, in a certain sense, did not have to worry, you know, or address the kind of ethical quandary that you're talking about. Um because it's a book that's situated in the scholarly field of law and humanities, uh, my ethical responsibility, immediate ethical responsibility, not kind of a broader ethical responsibility, immediate ethical responsibility was towards the text that I was reading. And in a certain sense, that is where the quandary lies, because you are already against the texts. because your job in the carrying out of your reading is to show what's wrong with the texts, right? But in trying to show what is wrong with the texts, two things can happen, as I was saying. One is that as a reader of those texts, I can end up demonstrating interpretive supremacy over those texts. And second, by establishing interpretive supremacy, I can say that because I am an expert on these texts, what I say about these texts is the final word, it's the truth about the text. And so I had to develop a method or an approach or a way of reading uh, that remained attentive continuously to this possibility. So, and why I'm saying this is because it comes very easily without ethical worry to lawyers that pursuit of truth is an unquestionable virtue, right? But pursuit of truth isn't necessarily an unquestionable virtue. It could be an extremely totalitarian mode of working in which where your truth becomes the ultimate truth. I mean, that's what what fascism is all about, which is why all of these new crop of propaganda films have very forensic, secular sounding names, Godra, something truth or conspiracy, uh, this files, that files. It almost sounds like forensic investigations into things. The aim of these are to establish the truth about the matter. And so this is just to say that I didn't have to work with the kind of ethical quandary that an anthropologist will have to. Of course, there could be a larger question asked about the book, which is why focus on Gujarat 2002 and not on 1984, or not on the Nelly massacre, or not on something else. My simple answer to the question is that I was in Gujarat. It, uh, you know, fundamentally changed the way I live in this world, um, and that's why.
Thank you so much, Oishik. Now, I think if anyone has any question, that would be great. Otherwise, I have a question. So, when I was going through chapter one, and somewhere you have written that, I mean, India is somewhere moving towards mix of neo-fascism and neoliberalism. I mean, this is a growing debate in Indian left circle where some left parties are, tending to uh, accept that India is somehow entered into the neo-fascism area, whereas some political parties, some left political parties are still in confusion. They have their own analysis. So while writing this book, I mean, what was into your mind as a legal or legal humanities scholar? I mean, this tension always remains in our mind when we write something, especially which is very political. So I just would like to know about your say on it.
Hmm. I mean, there's of course the left, and of course there's the party left, and the left and the party left are different things. They do different things. They are motivated by different things. Sometimes they see eye to eye, sometimes they don't. And as someone whose entire growing up happened during the CPIM rule in West Bengal. Uh, uh, that was very clear to me growing up of that, the left doesn't speak in one voice, doesn't say the same thing, does very different things. Um, so I have no, like Zishan was saying it earlier, for me, there is no left meta narrative in that sense. Um, I One of my favorite articles as a legal scholar is one by someone called Margaret Davies, and the article is about critical legal methods, and she calls her way of approaching methods an anti-manifesto. Uh, so in a certain sense, that article demonstrates how we can think with both modes of structuralist critique, which is what the so-called left inheritance is, amongst critical scholars. But that left inheritance also, in a certain sense, can make us encounter the limitations of it. So I can begin with the manifesto, but if the manifesto starts dictating the way in which I approach my thinking and work, then the manifesto becomes more important than the work itself. So at a certain point, uh, the anti-manifesto turn for Margaret Davies is a mode of doing both external and internal critique simultaneously. And so, in a certain sense, for me, critical legal scholarship is about that tension, right? That, how do I balance, in a certain sense, my structuralist impulses to see the base and the superstructure, to see hierarchy and domination, but also to recognize that everything cannot be explained through hierarchy and domination. That, uh, so, or what appears to be hierarchy and domination under certain circumstances might not be the same. So, the whole history of, for example, uh, the the emergence of critical race theory out of what used to be called critical legal studies in North America, is a story of that, the story of the limitations of a certain kind of structuralist thinking that was so class oriented that it did not, take race into account. Um, yeah, so I don't have a manifesto in that sense. Uh, that's the reason I guess I do work that is called not really law. So I don't have a disciplinary manifesto either, let alone a political one.
Thank you, Dr. Oishik, for your uh, answer and then your
If
time to the session. Yeah, Jisan, I think you have something.
if time permits, I just have one question from Professor Oshik. Okay, the last line with which you end the book, it's called "The New India has got the fascism that it deserves." A couple of months ago, or like it every now and then comes on social media, this very quote is attributed to, I think,
Ijaz Ahmad.
some friend. It's
Ijaz Ahmad.
Jazz Ahmed. I checked the citation over there, but it said like a society gets the criminal that it deserves. It means something like that. It keeps moving on social media. So, but by this statement, do you mean? I mean, do you draw the genealogy of this fascism way back from 1950s or the 1991 demarcation which you are doing, where the configuration of this new India comes together and a different kind of picture? Because by reading this we get a sense that this was in the making. Now the final picture has emerged. It's there on the means, like means you have used that phrase, kind of law scape kind of thing, so a law space kind of thing. So now there is this space where the fascism has finally come, which was in the making since long. So this
Yeah,
long is 1991, or at the constitutional moment of 1950 itself, there was some traces of it, and now it has fully developed into some kind of means it's no more putative. It is no more putative. It is something very tangible, which can be seen, heard, felt, kind of thing.
yeah, I would agree with what you're saying in that sense, and I think the point of ending with that Ijaz Ahmed reference is also to say that it's not it's not the card-carrying fascists who've brought us to this point. It's also the liberals and the secularists with a commitment to liberalism and secularism who are as complicit, if not more, than the fascists who have got us here. Right? So so the story here cannot be a story where under the current circumstances, some people can say that, but we didn't do this, and then claim absolution through accusation. Because as soon as you accuse, accusation is always accompanied by the absolution of the person or the persons who are accusing. So in the sense in which I use that closing, sentence is to say that, yeah, we've all done our bit and are
Thank
continuing to do so.
Uh,
Yeah.
Thank you, Oishik, for your detailed description of your book and your understanding of contemporary India that India is going through right now. And it has not started, I mean, in 2002, or it started before that only. So thank you again. If anyone have any question, I would go for the last question. Otherwise, I would go for wrapping up this session. Anyone has any question? So yeah, I think it's time to wrap it up. So I would like to thank Dr. Oishik for his time, giving for speaking from margin. So just to give you give you an overview of speaking from margin. So it's a platform built by students, research scholars, where we discuss about contemporary issues in global as well as in Indian context, and basically we bring social sciences approach to contemporary issues. And we have students, we have research scholars, we have early career researchers with us who always wait for some kinds of book review sessions, some kinds of webinars that goes on to analyze the current scenario. So yeah, thank you so much, Oishik, for your time, and thank you everyone. Thank you, Jishan, for your time going through the book and bringing your critical perspective as a legal practitioner and aspiring researcher. Along with that, I would like to thank all the participants who participated in this session asking questions. And after this session, we'll be uploading this video to our YouTube channel as well as LinkedIn and other various social media platforms. So I would request everyone to share this video. And thank you once again. Thank you, everyone. And thank you, Vidyasagar, for handling all these technical things from behind. And thank you, SFM team, who were present as well as who are behind the session to organize such sessions. So thank you so much. Thank you, Ashik. Thank you, Jishan, Vidyasagar.
Thank you, everyone,
thank you. Thank you. Bye.
for taking time out on a Sunday to do this, and to Zeeshan especially. Really appreciate your engagement, and to
It's a
the
pleasure, means I got an
and
opportunity
the
to
team.
read this wonderful book.
Okay. Hope to see you when I'm in India next.
Sure.
Okay.
Okay. Bye.
Bye bye.
Bye bye, everyone. Bye.